Morning, everyone, and welcome to our Contracting for Agile, Is It Possible webinar. Today, we have got Andrew Craddock, Director of the Agile Business Consortium and founder of Enlighten Training. We've got Richard Stevens, an independent lawyer, and we've got Stewart James from Agilex. So we are here to continue, I guess, the conversation that we had on our previous one. But firstly, if you'd like to pop in the chat where you're from, and then I'll pass you over directly to Andrew.
Okay, thank you, Emily. So contracting for Agile, is it possible? I guess my response is I hope so. So let's have a quick look. I'll tell you why I hope so. So I'm going to start off with some thoughts before handing you over to my learned colleagues, the lawyers, to debate the detail. So I started my career working for a major international airline back in 1988. Within a few years, in the early 90s, I'd graduated to being a project manager. And my life as a project manager was not always great. Main reason for that is that our projects that we ran typically went significantly over time, went significantly over budget, and normally achieved very low sort of satisfaction within our internal business, with our internal business partners. So the projects I was working on were primarily building IT systems for the business to use at the time. We did some work and realized that actually one of the major problems that we were having that was causing this time overrun and cost overrun and poor satisfaction was the process we were following. Like everybody else back in those days, we were following what would be traditionally called a waterfall process or a sequential process, whereby our project lifecycle went through the concepts of ideation, initiating a project, planning what was going to be done, realizing the outcome of that project, and sort of launching at the end, followed by a long and happy reaping the rewards phase was kind of the expectation. The reality was that projects typically actually ended in failure if you're judging that by being on time, on budget, and having a satisfied customer. They were never completely successful. Quite often they weren't complete and total failures either, but regardless, they did not perform as expected. What resulted then was blame and recrimination for the failings of the project, the way it was run, the way it was managed, etc. We tried over a number of years prior actually to me really sort of becoming a project manager. So in the years leading up to that, lots of effort had been put into trying to do it better. And one of the big focuses on making sure we got the upfront work done properly. Yeah, if we managed to get that done properly, we were very precise about what was needed, and then we managed change throughout the realization process, then we'd end up with on time, on budget, happy customers, all of that sort of stuff. Yeah. The reality though was that didn't work. Yeah. What we were able to do, however, was justify our failure. Yeah. So it was more clear why we had failed. We were able to deflect the blame away from one party because we always had things in the specification that and the change control that explained why things didn't work as they should have done, and we were able to suppress the recrimination. So, there was no real difference in outcome. So nobody was any more pleased with the results, but at least I was able to, and my colleagues were able to claim much higher on time, on budget stats because we had change control. Yeah, so provided you timed the last project board meeting right, then you could always finish your project on time and on budget. Didn't fool anybody, obviously, but we were able to pretend. So we did some work, the airline did some work and adopted and contributed to DSDM, Dynamic Systems Development Method, which was one of the first, if not the first, agile approach to projects that were that came to the market back in the mid-90s. Using DSDM, time overruns became trivial, cost overruns became trivial, if any, customer satisfaction was high, and we also managed to achieve across the entire sort of 2,000 strong IT department a 25 to 300% improvement in productivity, which was externally benchmarked. So there was no fooling ourselves here. This was externally benchmarked. And that was a real eye-opener. It completely validated the idea that the process was wrong, because all the people, we've got the same people involved, they were just working in a different way. A few years later, the DSDM consortium, as it was then, the Agile Business Consortium now, contributed to the Manifesto for Agile Software Development. Yeah, and looking with hindsight a few years later at these value statements and the principles behind it, it was clear that this is why our projects in the airline were succeeding. We were valuing individuals and interactions over processes and tools, working software over comprehensive documentation, customer collaboration over contract negotiation, oh, there's an interesting couple of words, and responding to change over following a plan. Yeah, not ignoring the stuff on the right, but making sure that they were subservient to the things on the left. Our observation was that the old way of working really majored on the things on the right. Yeah, so those were the problems, and I think a lot of the issues we have today kind of play to that. Before I hand over, I just wanted to put one more little thing into the mix, because what I described up till now was all internal to the airline. Yeah, I was actually involved on the periphery of a major outsourcing contract as well, around about the same time as internally we were adopting DSDM. It was a multi-million-pound project involving a big systems integrator, and it was based on the old broken process. I say broken now because it's clear that's what the process was broken. That took literally years in the planning, 2 years in the planning. The specification had a height of approximately 3 meters. I know because I saw it. And that's A4 pages stacked one on top of each other, 3 piles about 1 meter high. Was the specification for the system that we wanted, and it was also, very importantly, the basis for the contract. Yeah, there was all sorts of stuff, as you will hear, around the contract about how it should operate, but what was needed was defined in these specifications. That project was cancelled about 3 years into the realization phase. Having delivered nothing, cost millions of pounds to both parties, no prospect of meaningfully delivering anything, and it was an agreement between the CEOs of the airline and the systems integrator to walk away rather than litigate. They just worked out all they were going to do through litigation was spend more money on an argument that would inevitably end up as nobody's fault. What we learned there was you can't transfer the consequences of failure to the other party. Yeah, it doesn't matter. You could, even if we'd managed to pin the blame entirely on the systems integrator, the business would not have been able to move forward in the 5 years it wasted on that project. So my question is, would it be any different today, 25 years later? And this is where I'm going to throw the floor now to Stewart, who's going to say, yes, Andrew, it can be better. And over to you, Stewart.
Thank you, Richard, and thank you for that introduction. And thank you also to the consortium for allowing Richard and I to follow up from Mirko Kleiner's presentation from a few weeks back, where he proposed the view that you don't need a contract. Now, hopefully in that gap, I've managed to get my slides up and you can see those all. So Mirko's view that you don't need a contract for Agile is possibly a position that would hold true in countries where you've got a codified system, where a lot of the elements of a contract are codified and imposed on the parties regardless of whether they write it down. But that probably doesn't work in common law countries like the UK, which really starts off by looking at what the parties have documented. So whether it's that 3-meter high specification or the document that goes in front of it called the terms and conditions, that's where they're going to start. Now, I'd quite like to start just with a very, very quick poll to find out who in the audience has had some experience of drafting contracts or been involved in the process of drafting contracts for Agile. So Emily, if you could run that, and we'll give you a few seconds just to have a think about that and answer that. And I think we'll close the poll in 5, 4, 3, 2, 1. And the results, Emily, if we can. Okay, so we've got about a third of the audience has had some experience of being involved in the process of creating contracts for Agile. It'll be interesting to probably follow up at the end of this and see how confident the audience are that you can contract for Agile scenarios. Now, Andrew, in his short introduction, introduced the fact that there's a difference between sequential or waterfall drafting contracts and iterative developments or for the Agile approach. So I thought just very, very quickly, just to make sure we're all on the same page. So a quick description, as I see it, of the difference between sequential and iterative. So in both instances, the customer is going to start out with its general requirement for what it wants. And in this instance, I've chosen a simple design idea for a hatchback car that our customer wants. Now, under the sequential approach, of course, that's then handed over to the developer, the supplier, who will take the idea away, design it, and come up, however long later, with their solution. And you hope it's going to fit your needs. You might not like all the features or the functionality, but you've got what you've got based on the supplier's interpretation of your requirements. And any changes you now want to make to that are going to be fairly expensive and difficult to implement. By contrast, if we look at the iterative approach, we start off with the same design brief, and the immediate result is pretty quickly we get something back that's starting to fit our design requirements. And then over a series of iterative stages, we'll enhance that to get to the final end result, the car that actually met our initial requirements, or at least the car that we now understand that we wanted, having gone into that process. So it should be pretty clear from that collaboration has a very high role to play in this whole process. And that's going to require quite a lot of change, and it's also cultural change. You've got that greater collaboration, you've got the customer participation in feedback loops and greater stakeholder involvement in the whole process. And you've got the need to change, to adapt the design to meet the requirements as the customer better understands them and as the supplier better understands the needs for them. So you've got an element of sort of research and development, test and trial type approach that's led to the fail fast, fail often principle that you often hear quoted in terms of Agile approaches. And then symbiotic with that is the need to continually test the outcomes of each of those iterative developments and for the customer to accept that as a process. However, because you've got a large amount of cultural change going on in the movement from the sequential to the iterative approach, you're going to get a lot of resistance. That's inevitable, and we know it happens in all walks of life. Whatever you do, and no matter how sophisticated you are, there will be reluctance and resistance to that change. And that leads to a number of myths and mistaken understandings of what Agile is all about. So quite a lot of the legal profession is still in that sort of mindset that you can only use T&M, time and materials type charging models for Agile, and the legal profession tend to be quite reluctant about that because it lacks the certainty. And also that Agile might only be suitable for small projects or for internal projects, a little bit like Andrew's internal Concord project. You may also come across the myth that there's a lack of specification, which leads to the uncertainty of outcome. Again, I think we can dispel that as we go through the process. But despite all that resistance, that reluctance to change, the myths that persuade customers not to go through the process, we're now operating in an environment where the parties are seeking to digitize their services, and there's a very great imperative to be first to the market in that process. So as an industry, we are going to have to change. We are going to have to find better ways of contracting for these services, where sometimes good is enough, or good enough is enough. So let's have a look at how that affects the way we look at this from a contractual perspective. We've got to look at it culturally differently. Now, the problem we have as lawyers is at the moment, there are very few legal precedents that work in an Agile environment. Because of all those flexibilities, because of that collaboration, the processes that we've used in the past support the sequential contracting methodology. They don't support the iterative approach, where there is going to be the greater collaboration. And I'll come on to how we deal with that in a moment. The lawyers also have to look at the fact that there are multiple methodologies out there in the market. The last time I looked at it, there are something like 80 or more different Agile methodologies that can be chosen. So whether it's Scrum, Kanban, SAFe, XP, DSDM, Agile Unified Process, there are lots of different approaches that you can take. But we need to try and be agnostic of the methodology when we come to drafting the contract. And then there are a variety of different drafting pitfalls that you can the lawyer can fall into. And the common ones that we tend to see are things like process description. Now, with a sequential contract, with a waterfall contract, the lawyer isn't there to describe the process, and you don't see that written in the contract. But a lot of the templates that you're seeing in the marketplace at the moment for Agile try and describe the process as if we have to try and teach the supplier and the customer how to do Agile. You don't need to do that. You just need to identify the method that the parties are going to follow so that both parties understand what that process is going to be. Then you often get something called process conflation, where the draftsperson combines elements of Agile drafting or drafting for iterative contracts with drafting for sequential contracts. And that creates a sort of Agile type contract that doesn't really serve the purpose. The other pitfall that you often see is jargonization, where the draftsperson gets hold of the Scrum dictionary and throws all those technical words into the contract, but without really understanding how they fit the process or fit the roles and responsibilities of the parties. So the truth behind this is drafting for Agile is difficult, and it's because of that you often find that the contract tends to follow that waterfall type process, and that's because lawyers often like to rely on terms that they've drafted in the past, because they know they have certainty of the outcome of what that's going to deliver. So let's drill down into some of those drafting challenges in a little bit more detail. So the first one is the agreement on scope. And just because it's agile doesn't mean to say that the contract has to dispense with some form of a specification document. After all, the manifesto value is working software over comprehensive documentation. That doesn't mean to say you dispense with the documentation. It just places the emphasis on getting on with the coding side. But a contract still needs to have a baseline for the parties to understand what's going to be delivered and the relative importance of the features and the functions that those requirements contain. So you still need your prioritized requirements list. The problem for the parties is the uncertainty involved in setting the scope before any work has been done to understand those requirements. Now that dilemma is often captured in what's called the cone of uncertainty, which I've taken that graph out. But whatever you call it, whether it's a terms of reference or a solution architecture definition or vision, you do need to have some form of high-level view of the requirements from the suppliers and the supplier's proposed solution, because that is your baseline. But you've then also got to recognize that that baseline is going to have to change, and change can happen for a variety of different reasons within the contract. For example, you may just have a simple change to the terms of the contract, whether it's payment terms or governance model, and that just needs to be documented by the parties and signed off by them. But the one that most suppliers and developers are concerned about are the operational changes and the way the development is brought into effect. So changes in the order that the features are developed, or what features are developed. And you may therefore be looking to make changes to the prioritized requirements list or product backlog. Now, from a contracting perspective, that shouldn't be a problem, because operational changes are really just changes in the way that you are delivering and supplying the solution. You're not actually changing the terms of the contract. And the key element here is to ensure that those changes are recorded so that the parties can understand when a change was made and why it was made. Now, the basis on which that can happen doesn't need to be the formalized change control process that lawyers typically want to impose into a contract. They can be much more flexible and can just simply be keeping a good record of the development program as that changes, and keeping different iterations of that as you go through the process. What that does require, though, is collaboration between the parties. And collaboration is built on mutual trust and good faith. Now, there is no general doctrine of good faith in contract law. There's been some movement towards it. Those in the UK will be aware that a number of postmasters have recently won a case against the Post Office in respect of the Horizon accounting system. But in that instance, what the court was really looking at was the relationship between the parties and the enduring nature of that relationship, and the fact that the Post Office had effectively acted in bad faith. So that's not about creating a doctrine of good faith, but it's identifying when the parties have failed to act with good faith. So the court will impose limited rules to ensure that contractual discretions aren't exercised unfairly or arbitrarily in the process. But it doesn't impose an obligation on the parties to act in a particular fashion. And for those that are involved in working between two organisations and contracting between them, you'll know that both parties are really there to serve and look after their own interests. So if you want to go a little bit further than and impress some obligation of good faith, you will need to put some obligations in there relating to that partnering, the partnering aims and objectives of the parties and how they are going to act. And there, a key part of the contract is to allocate duties and obligations to the parties so that they have a clear understanding of who holds the responsibility for any action or activity. And you could do that with a simple responsibility assignment matrix or RACI table, for example, provided that the parties know and understand who bears the responsibility for a particular obligation. Of course, a collateral effect of working collaboratively is the potential for both parties to contribute to the development of intellectual property rights through the development. Now, IPR and joint ownership is one of the areas where lawyers tend to get a bit nervous because the rules around joint ownership can become quite complex and are not necessarily in the best interests of both parties. For example, the joint owner of any IPR can only use it for its own purposes. If it then wants to go on and license that to a third party, it's got to get the consent of the joint owner, who then has a power of veto over it. So quite often, it's better for the parties to recognise that the IPR will be owned by one of the parties, and the other party to the relationship is given wide licensing rights as to how they can use that. It's also probably fair to say that in a lot of instances where parties in their colloquial thinking believe that there is joint ownership of IPR, it will still actually really only have been created by one of the parties, and that's normally the supplier. And it's also normally the supplier who's best placed to own the IPR rights in any event. And again, a further consequence of this collaboration or this need for collaboration is the fact that the customer is going to need to ensure its staff is available to participate in the project at all material times. And there will be a need for the contract to require the customer's staff to be available as and when they're needed to take decisions. But not only must they be available, they must also be empowered to take those decisions. Now, that can be a little bit unnerving for senior management because you are potentially giving junior members of staff the power to take fairly important decisions during the development process. Shouldn't really be a problem because these are the people who are generally going to be using the outputs or the outcomes of the development and therefore really ought to be involved in taking some of those decisions. But that then may feel difficult for the customer, particularly around times when the customer has to sign off on the acceptance of various elements of the solution. Now, shouldn't be a problem because the short development times within an iteration, typically 2 to 4 weeks, means that you're only developing relatively small bites of the solution. But if there was to be a mistake in terms of signing off a development, you haven't actually incurred large amounts of costs within that short time sprint or iteration. But essentially, as long as the supplier has developed the solution to meet the acceptance criteria of that iteration, then it should have the right to be paid for that iteration. That's balanced out for the customer because it should have the right to end the contract once its needs have been met, this elusive definition of done. And in that instance, the customer does actually have the whip hand because it is able to identify when its needs are met as those iterations come through, and it should have the right to end the development once those needs have been met at the end of the next iteration. In other words, it can end the contract at any period of time and shouldn't therefore fear the need for the iterative development, where the solution is seen potentially to grow without control. In essence, what the customer will be doing is paying for development that meets its needs, and not development of needs that it thought it might require, but actually when it comes down to using the solution, never actually required in the first instance. The result of that is the supplier gets paid for the successive iterative developments, whereas the customer has the right to terminate when its needs are met. And those two rights should, in essence, balance out. Now, for some reason, my slide doesn't want to advance. Oh, it's just being very slow thinking about it. Okay, so just talking briefly about some the commercial models. In essence, T&M is often cited as the true agile approach, although critics argue that it favours the supplier by disincentivizing efficient practices and encouraging scope creep. However, you could clearly argue that the iterative process gives the customer lots of control over the process because it has visibility. It's always being expecting to receive the next iteration out of development, and can therefore see what is going on. The supplier essentially has nowhere to hide, and on the basis that the customer ought to be able to have the right to terminate when its requirements are satisfied, if the supplier is not delivering useful, workable software, then the customer has always the ultimate control of turning off that supply. By contrast, the sequential or waterfall process, the customer has limited visibility of what is going on. It has long development cycles where it's paying at the end of that cycle, and doesn't know what it's going to get until the solution is delivered. And if there is a mistake within that development, the cost of rectification is significantly higher. So there shouldn't be concern about the use of T&M charging. However, any commercial model works with Agile as works with the waterfall. So you can use fixed cost, and the DSDA methodology is actually set up on a fixed cost basis. And as you can see there, a list of other possible models that could be used. I said there weren't many contract template examples around. I've listed a few there, which you can go and look at. They're quite an eclectic mix of styles. The practical law one is a little bit Agiful. The Lexis PSL sits behind a paywall, so difficult to get to, but is essentially an Agile model. The GDS Government Digital Services in the UK DOS contract is a little bit like sort of sequential iterative drafting. The Norwegian PS2000 contract, I've never actually had a look to see that because you have to pay for a license to use it in the first place. And the Danish KO3 contract is a government contract for the Danish market, which again is a little bit sort of sequential iterative type approach. But the good thing for those members of the consortium is, of course, you have your own template contract to use, which is available for download off the website free of charge. And it even includes guidance notes, so your own lawyers can work out, follow how to use it. At that point, I'm going to hand over to Richard, who's going to tell you some of the things that can go wrong when you are drafting for Agile contracts.
Right, is it over to me? Lovely. Thank you, Stewart. Thank you, Andrew. Now, Stewart, you and I have crossed swords before on the subject of agile and agile contracting. And I started out as an advocate for agile contracts, for agile projects. And I'm now cast in the role of villain as answering Stewart's case. And so I'm the wrecking ball. I'm here to destroy. And so what I want to do is just run through a few points showing why I don't think agile contracts are actually really possible. I should say that I'm an English lawyer, and that means to say I'm talking about English law. And I've just looked at the chat, and there's people from all over the world. I saw someone there from South Africa. I saw someone there, a couple of people there from the Netherlands. Goedemorgen. You've got in the Netherlands, I think you've got a civil law system based on the French civil code. In South Africa, you've got Roman Dutch law. I think I saw someone from the Philippines. I don't know what type of legal system you've got there, but I'm talking about English law, and I should specify that. Of course, English law is still very much an international legal system used in many, many contracts around the world for different industry sectors. What I want to do first off is talk about what the purpose of a contract is. And if you stand back and just say, well, why am I going into a contract? If Agile, as Andrew and Stewart have indicated, is so perfect and so wonderful, and it guarantees brilliant results 100% of the time, arguably, you don't need a contract at all. Contracts are there for when things go wrong. And it's when they go wrong that you need to have the contract. It's not there. You may think a contract is there simply as part of some government job creation scheme for lawyers to give us lots of money. It's a phase you go through, and it's a good and charitable cause. Nothing I say is intended to deflect you, of course, from that goal. But why should we have a contract? It's there to answer the questions when things have gone wrong. If it doesn't answer that question, excuse me, the contract has failed in its purpose. So with that by way of introduction, let me switch to my slides and share my slides with you. And you should be able to see my slide deck now. I'll just maximize that. Okay, contracting for Agile, is it possible? And I said there, no, it's not. So that's the simple answer. And I could rest my case there. But let's have a look at some reasons why. And there are basically two reasons, and they're two different sides of the same coin. One is a legal reason. I say I'm an English lawyer. It may be different in your jurisdiction. I'm an English lawyer, and there are legal reasons why it's very difficult to contract for Agile. Even if you do, there's a commercial reason, what I call the FD, the financial director reason. And I'll cover that in just a minute. So we've heard about Agile, and I'm not going to go through it. It's iterative, incremental, it's agreed on the fly. It's when lawyers then start resorting to horrible expressions. They start talking about, the parties working in partnership. Stewart's already mentioned that horrible expression, good faith, which is not a concept that English law has. I know from Dutch law, you do have a concept of good faith. It's not the same here. You could, as a tip, you could look there at that slide, you can see reasonable endeavors, reasonably agree, good faith. When you get a contract to review, just do a word search for those expressions. In English law, the higher the incidence of those expressions, the likelihood is the more meaningless your contract actually is. So why the short answer? As I say, the short answer in legal terms, in English legal terms, is English law doesn't recognize a contract for what they call an agreement to agree. It simply doesn't work. And I can give you some examples of that. Even if you can make that work, you then end up with a contract which is effectively one for services, and it fails the FD, the financial director test, which I'm going to tell you about in a minute. Reasonable endeavors. There's a very good topical example of that. Think of the AstraZeneca dispute with the European Union. And we were introduced to that that horrible expression, that monstrosity, best reasonable efforts. Go back to what I said the purpose of a contract is. It's there to resolve something that's gone wrong, where there's a disagreement or a dispute. It's not there to create a further dispute. And as we've seen loads of lawyers now chipping in, saying what they think best reasonable efforts mean and what the result is in that case. But simply having that in the contract hasn't resolved the dispute. It's actually created a further dispute. It hasn't brought the parties together. It's driven them further apart. So let's have a look at the legal reason for no. Agile projects do fail. We don't get in England many IT disputes that go all the way through to trial. They're too big and they're too expensive. The parties nearly always settle them along the way. In recent years, we've had 3 that have failed disastrously for the supplier, I should say, for the provider. De Beers, B-Sky-B, and most recently, CIS General Insurance against IBM. In all of them, the judge had to consider the use in those cases of agile methodologies. Agile was used in each of those cases and it failed. The most interesting thing is what the judge said in the De Beers and Atos Origin case, because the presumption in English law, it's not a presumption, the approach of the courts is to say that the supplier takes the responsibility for the success, or more likely the failure, of the project. As the judge said in that case, Atos went into this contract with its eyes at least half open because it had done an initial requirements analysis phase, in the sense that it knew or should have known that it had not acquired a good grasp of the detail of De Beers' diamond sorting and aggregating process. As I say, the courts approach contracts on the basis that it's the supplier who has to bring them home to make them successful. There's a very good example of that. I haven't given it in the slides. Perhaps I should have done, of the MTH and EON case, where a contractor was mandated to use a particular technology to build offshore wind turbines. And the customer mandated the use of that particular technology. Neither party knew that that technology, which was an international standard, was actually defective. And as soon as the wind turbines were built, they started falling down and took about 25 million euros to repair. And the result of that went all the way to our top court. And the judges then applied this approach to contracts. And they simply said, the law cases have always taken the view that if something goes wrong, it's the provider, it's the supplier who takes the responsibility at the end of the day, even if the customer has told them how to do it, what technology they should use to achieve that project. Think how many times an IT project, it's the customer who's setting out the requirements, mandating this. In an agile project, you could be agreeing lots of things on the fly. But the approach of the courts in England is that it's the provider who's going to take the responsibility if it all goes horribly wrong. Now, you can provide for something different, but that would require specific drafting. We use this reasonable words. I mean, there are so many examples on this. I could go on and on and on, but let's have a look at just one of them. Morrison Swanton Care. Mr. Morris sold the shares in his care home business to Swanton Care for £16 million. Very nice. Thank you very much. Very good indeed. And as you can see there was a paragraph that said he had the option for a period of 4 years to provide certain consultancy, and he did. £1 million a year. Thank you again very much. But he shall have the option for a period of 4 years, and following such period, such further period as shall reasonably be agreed. As shall reasonably be agreed. Mr. Morris said, but that means you have to agree a reasonable extension to the contract and keep paying me £1 million a year. Swanton Care said, not likely. As far as we're concerned, it's all over. Went up to the Court of Appeal and they said, it's a meaningless thing. In English law, it's an agreement to agree. And you can't specify that it has to be agreed reasonably. It doesn't mandate any particular result. It's a thing writ in wind and water. And this comes up time and time and time and time again in the courts, where lawyers have resorted to this ghastly wording of reasonable endeavours, reasonably agree, and all the rest of it. And the courts have time and again thrown it out. Now, there are some legal ways of getting around that in drafting, which I'll look at briefly in just a minute. And I'm giving you some more examples there. I'm not going to go through it. The commercial reason for no, I talked about the FD test, the financial director test. When I was active in Agile communities a couple of decades ago, I was active trying to put together a contract for DSDM as it then was. It's moved on since then. I was talking about this with a financial director from a medium-sized enterprise. And we were talking about the Moscow rules and the minimum usable subset and all the rest of it. And he was quite a bluff, gruff sort of chap. And he said, look, he said, in my company, I have final say-so, final sign-off on a contract for buying in something. If I'm buying in a computer system, he said, £5 million, at the end of that contract, he said, I want to see it. I want to touch it with my fingers. I want to hold it. And I want to know that I've got at least £5 million worth of value out of that contract. If you talk to him about Moscow rules, minimum usable subsets, fail early, fail often, fail fast, fail often, all these things that have been milling around in the Agile community, he simply fails what I call the financial director test. He said, I'm not going to sign that off. I want a waterfall style contract guaranteeing me results. He was going back to what I said in the De Beers case. I want something at the end of it. And if I don't get it, I want someone to blame and someone I can sue for the money. The law can help, and it can get around this. There are drafting techniques you can use, but whether it makes the contract worthwhile is a different question, because even if you make the contract watertight in the sense that the courts will enforce it, you have then to ask, would it pass that financial director test? So what can you do? Well, you can, if you could have reasonable agreements and reasonable endeavors, which could be a thing written wind and water and totally meaningless. But you could then say in the drafting, there's a position in default of agreement. So this happened in the Phillips Petroleum case, where there was an agreement to use reasonable endeavors to begin the supply of natural gas from the North Sea. And the Court of Appeal was sniffy about that, not really enforceable. But what the draftsman had done in a contract was to say that after 6 months, in default of agreement, supplies had to start. So there was a fallback position in the contract. That worked. Of course, the trouble then is, if it suits one party, as it did here, just to sit back and do nothing for 6 months and wait for the default position to come into force, well, they can do that under English law. You can also provide a system for resolving disputes and disagreements. This came up recently in the ABP and Tata Steel case. This was a 25-year agreement for the use of a harbour by Tata Steel. Halfway through, either party could request a renegotiation in the event of major changes in circumstances. And Tata Steel alleged that. And there was a six-month period provided for renegotiation. But what saved the draft again was, if they hadn't reached agreement, the contract would go off to a third party who would make a binding determination for the parties. That saved the agreement. Of course, the problem then is you could do that in your Agile contract, but then, of course, you're introducing potential delay. And of course, the third party may decide against you. So that's a risk. You can use some form of adjudication, as they do in construction disputes. It's possible, but it may not go your way. And it's kicking the can down the street, because the contract is no longer providing a resolution. It's simply providing a method for resolving it, which may go against you. So you don't know at the beginning of the contract how it's going to turn out at the end. And you can, of course, put some sort of measure in for the contract, a reasonable price, a reasonable time scale, or whatever it may be. The courts do allow that under English law up to a limit. What they won't do is rewrite your contract for you. And I will say, if the parties couldn't reach agreement, the English courts won't provide a resolution for a dispute in that case. So that you're then back to the best reasonable efforts and simply the uncertainty. Is this contract enforceable? Is it not enforceable? If it's enforceable, what on earth does best reasonable efforts mean? And does it mean that AstraZeneca is liable, or does it mean that the EU simply got a bad deal? As Stewart mentioned, there are Agile contracts out there. I don't have time to go through them. I put some notes in there. Remember what I said earlier. As a tip, when you get a contract in English law, just do a word search for reasonable, good faith, reasonably agreed. The higher the incidence of these expressions, the higher the likelihood is that you've got a meaningless contract. So I think Stewart mentioned this one. I'm not going to go through it in detail. It's very, very short. Well, I've gone past it, I think. And I was going to find it. Short-term statements of target outcomes are called off, so you've got a whole series of mini contracts. But what do you have to do for each one? Well, the supplier shall use reasonable endeavours. Well, that doesn't resolve the problem. It's failed the first duty of a contract, which is to resolve a dispute, not to create a further dispute about what it actually means. There's this one. PLC is an online legal resource for lawyers, and they put up an agile software development contract, which they expressed as being pro-customer. I can't go through that. If you go to the bottom bullet point there, you can see on over 36 pages, there are no fewer than 29 reasonables, 26 reasonablies, and 4 good faiths. Okay, remember what I said about English law contracts. The more you've used those words, the less likely it is that that contract is going to provide a good resolution to your dispute as you go through. So you can do these things. It is possible, but the techniques you have to use tend to make your contract very woolly, and it doesn't really then, it's not really then fit for purpose to pass the second test, which I've called the financial director test. Is it going to be a contract that is actually good for the customer, in the sense that the customer is going to want that contract because it guarantees that customer some resolution to its problems, some positive thing? So that's what I was going to say, and I will throw it open, and I think there may be some chat or there may be some questions, but back to you, Emily.
That's great. Thank you, guys. It's really interesting to see sort of, I mean, I'm no lawyer. I have no experience in agile contracts. So to hear the different stories and also some of the comments, one of the comments was from Nick, is it really the case that a contract is there for when things go wrong? In his opinion and his experience, if things go wrong, a contract doesn't help anyone. And I guess this is where you're coming from. It's you're sort of saying some of these contracts, they're so woolly, they're not there. From Andrew's experience, it wasn't there to help or aid the dispute.
I should explain that, Emily. If everybody knows what they're going to do, and it's a small scale development or whatever, it could even be a big scale development, if everybody knows what they're going to do and there's no disagreement about them, then in a sense having a written contract, it isn't going to be any use to them. It's only there where you suspect there's going to be a falling out or even a disagreement about the scope of what's going to be delivered. The financial director starts jumping around saying, where's the full system? Where's the full system? I don't want this agile partial delivery. And at that point, you want a contract you can go to that simply tells everyone what they should have done, so that there's no dispute. And the trouble with all these words of the AstraZeneca contract is it creates a dispute about a dispute, and it doesn't help the parties at the end of the day. Get a new FD.
Yeah, I think that could well be a good solution, because the thing that's interesting there is the naivety of that individual, Richard. You know, if that individual believes that you can specify a major deliverable like a computer system and then deliver to that specification, and that once it's delivered it will meet the need of the business, that is just being disproved by so many examples. Yeah, far more examples than not, that just doesn't work. So I would say the financial director has an unreasonable demand in that regard, and we shouldn't bother even trying to get a computer system in place, would be my view. You know, and my point there is the world has moved on, right? And people should realize that the expectation of that financial director is unrealistic and unreasonable. So how can you lawyers help us find something different that is going to be reasonable and workable, that we don't end up throwing the contract in the bin at the end of the day, because you know what, we ain't going to win anything if we go to litigation.
As I say, you can do that, Andrew. You can do that. And I gave you some drafting guidelines as to how you can draft around these things to deal with these things. But the more you draft around it, the more you come up with a contract that's not definitively going to answer the questions where there's a major dispute or a major disagreement. And where it doesn't do that, then you've got the problem. You've got possibly a problem about a problem, and the contract has failed in its primary function. And I fully accept, and I've been involved in Agile, and I got very involved with the DSDM and all the rest of it years ago. And I fully understand all you're saying about how wonderful it is and the world has moved on. It may be, Andrew, that the world of IT has moved on, but of course the FD I was talking to, and others beside, I mean, I call it the FD because I remember that particular conversation over a very boozy lunch, and he let rip on what he thought about DSDM. And I remember it very well, and that's why I call it that. But again, when I'm talking to the customer side of things, it may be the IT department is very sold on Agile. When it goes up to the commercial people and the lawyers who then try to draft for it, and so they say, well, what am I going to get for 5 million quid? At that point, it all tends to dissolve. So that's the problem. How can you do that?
I come back at that and say that the contract is not there so much to litigate, but it's there to act as an aid memoir of what the parties have agreed and who's agreed to do what within the process. So it should be a living document, and it should be something that the parties can refer to refresh their minds about where those roles and responsibilities sit. Unfortunately, what tends to happen is they get used and pulled out prior to litigation, and then they just act as a series of hazards that the parties have to navigate through when they do go to litigation. But if it could be used as the aid memoirs, as the governing document for the contract, then it could actually help both parties in achieve their aims. When I used to encourage junior lawyers and coach them in their drafting, I used to describe that there are two types of contract: a contract drafted to negotiate and a contract drafted to litigate. If you're only interested in beating the other side over the head with your Bible that's the contract, you're doing the latter. But if you actually want to have a meaningful collaborative relationship with the other side, you draft to negotiate.
Agreed. I mean, that's a good way of putting it, Stuart. Steve Ash has come up with another useful point: 2.5 million contract between bank and supplier, 1.5 pages of A4. There was something which Scottish and Newcastle Brewery came up with, lawyers came up with, and they called it the path clearer concept. And it's a point that someone else made, which was that every time you have a dispute, when you get out the contract never deals with the thing that's actually become a dispute. So why bother with a contract? And what they did, therefore, for their contracts of procurement was just have 1.5 pages, just reduce the legalities to the bare minimum. And they said, basically, when they got to a dispute, you just sorted out the problem and you avoided litigation because they're both big boys and girls and they just wanted to come to an agreement to get rid of the problem. So it is possible, that path clearer concept. I don't know what happened to it, whether they're still using it. But it's possible to do that. The reason why English law contracts have become so long is because all the clauses are there because they deal with common situations. That's the reason why it's there.
So Steve Ash has made the observation that you can have a £2.5 million contract between a bank and supplier and 1.5 pages of A4. I can certainly think of instances in my past where some major organisations, I'm thinking in particular in this instance of BP, British Petroleum, don't even bother with a contract with a small supplier because they know the relationship is far more important than what's written in a document. But ultimately, the parties have got to know what the journey is that they're setting out on and how they're going to get there. And that, I come back to this, use it as an aid memoir and set out, maybe have a racing table and an outline spec and base the contract around those.
It all depends on the relationship. I had a very interesting case recently, and I remember negotiating the contract over 3 years ago. And the bank, the procuring bank from my client software supplier, said, well, we'll have the contract, which comes to an end after 3 years, rather than, and we have to give notice to extend it. And I said, well, the normal way of doing that is to have a rolling contract that goes on from year to year, because you're going to forget to do it. Oh no, they said procurement's very thorough. We manage all our contracts. Guess what happened? Our client actually wrote to them in advance and said, you haven't actually given a notice to extend. And they wrote to them twice saying you haven't extended, and they just didn't extend, and they were out of time. Well, that's just bad luck. And my client turned around and said, all right, but if you want a new contract, price just went up. So much for the relationship in a sense there. And they said, you got a good deal from us last time, now we're going to charge you standard market rate. It depends on the relationship, how strong it is, what the position people find themselves in. And I don't think there's no rule. And as I say, that the purpose of the contract, as far as possible, is to eliminate disputes, to eliminate uncertainty. And as you say, Stewart, it should be an aid memoir for the parties. Typically in the IT sector, I find that it's not. They sign one thing. I also work as a mediator in IT disputes, and they can have enormous contracts. And after it's been signed, they never look at it again. And when it all goes horribly long, which it inevitably will, you're then left with a complete mess.
So I wonder if draft to negotiate is the answer then. That sounds like that's got some traction. Looking at a few comments on the chat, actually, that's a good phrase. Maybe that's one to explore and see what we can do with that.
Yes, Stewart. Again, tell me what drafting to negotiate is. Remind me.
It's trying to find the collaborative answers to problems rather than set down battle lines between the parties.
Yeah.
But I appreciate we're now over time, and Emily may want to be wrapping up the session.
Well, unless there's any other questions coming through in the chat. I mean, this has been a really interesting conversation. I've certainly learned some stuff this morning. So Stewart, do you want me to run that poll, or do you want me?
If there's a few people left to see whether they've changed their mind, there's no harm in running a wash-up poll.
Let me just. Okay, so this poll is just sort of on a scale of 1 to 6. What is your confidence level when it comes to agile contracting? And obviously, feel free to explain, put comments in the chat, and I will give you a few moments.
So Richard just voted for no confidence, I'm sure.
You didn't say I wasn't allowed to vote. So I suppose you said it was 6, what did you?
You want to share the results?
Yeah. So we've got a lot of people in the middle still. Yeah.
I think
I'd say that most people are actually not confident. It's mostly 3, 2, and 1. So I'd say we seem to have shocked them.
But I think what that's done is it's shown that the sort of debate between you gentlemen has actually shown the root of the problem, and really suggests that we need perhaps a different paradigm for this, whether that is no contracts, whether it's just something simple like a memorandum of understanding, whether it is building into a contract an obligation on both parties to negotiate their way out of issues as they arise. Seems to me to be the most powerful sort of opportunity that there is there. So yeah, right now, I guess confidence is going to be low, because actually there's nothing that's tested, is there, in that space, as far as I'm aware.
Yeah, it is a difficult space to fill, I think, Andrew, as I've explained, and and as I say, you can draft around it. There are techniques you can use to draft around it, but then have you got something that passes that, as I've called it, the FD test? And you may well say with Steve Ash, well, that guy should be put out to grass and he should be retired and get someone more collaborative in. But I deal with the real world, and when I'm a lawyer and I deal with clients, and if I then turn around and say, well, I've given you a contract that's not going to give you a result, my insurance is then on the line. So I snap back to basic principles. But fascinating.
Super. Thank you, everyone. Thank you, everyone, for your time this morning. Thank you, Andrew, Richard, and Stewart, for enlightening us all on the sort of the complication and the complicated elements of law and contracts, because I certainly didn't think there was that. I mean, I knew they were complicated, but yeah, I think there's quite the debate was still going on in the conversations in the chat. So it's a hot topic. Thank you very much for your time.
Pleasure.
That's great.
Thank you, Emily, for organising.
Thanks all.
Thank you all.